in the Baltimore office of Baker Donaldson. Today's coffee chat is the current state of labor law. Are unions cool again? And I'm sure, as you see on the news and are hearing a lot about the recent National Labor Relations Board activities, we have a lot to share with you today. And I'm really excited that Lewis Cannon, who's recently joined the firm, is co-presenting today. Lewis, would you please introduce yourself?
Hi, everyone. I'm Lewis Cannon. I am a traditional labor attorney, pretty much 100% now. I used to be well-rounded at one point, but I met one of our law partners recently, and she told me, hey, you're the L in L&E. That's great to have you here. So really excited to be here, and I'm sure you know this, but I have a whole lot to talk about today.
And as exciting, a labor associate joined us just this week as well. So our group continues to grow, and you met Carla Murphy a couple of months ago. So we appreciate the opportunity to speak with you about all the news at the National Labor Relations Board that has happened over the last probably about 6 weeks. Before we dig in, just those housekeeping notes that you're familiar with. There is a Q&A box. Please feel free to submit your questions. We'll do our best to get to them during today's presentation. A PDF is available in your resource list on the platform that you have in front of you, and we'll be emailing that as a thank you in the coming days to all the attendees. We love your feedback, and we do read those surveys, so please do complete the survey at the end of the webinar. We appreciate your time in doing that. Our agenda today is full, as Lewis said. We are going to briefly cover the Act itself and the board, a little bit about the two of those items, the current labor climate that we're sitting in as employers, developments in representation cases, unionization cases, basically. One thing we know you're interested in is the recent flip in the regulations and the view of the board on handbooks, work rules, and a whole bunch of other things. So we'll be covering that today as well. We'll look at expansion of employee conduct and protected concerted activity under the Act. The definition of employee has been expanded, and then we'll conclude and discuss some takeaways for you to think about after today's session. So with that, I'm going to turn it over to Lewis, and he's going to start with the Act and the board.
All right, so the Act and the board. I sometimes take this for granted, but in case you are not aware, the National Labor Relations Act applies to you even if you're non-union. The relevant portion of the Act is Section 7, that's up on the screen, and it's rather short, but it's pretty important. And what it says essentially is that employees have the right to band together, to get into groups and engage in action that's for what the NLRA calls mutual aid or protection. So in your unionized workforce, that's pretty it's pretty self-explanatory. You have the right to support a union, you have the right to vote a union in, you have the right not to support a union, all that good stuff. The way you see this arising in non-union workforces, though, is often employees getting together to complain about or talk about workplace issues at, say, employee meetings, like safety issues, pay issues, benefits, what have you. Employees sometimes will get together and sign a petition to oppose a coworker's termination. That's actually protected under the law. Filing a complaint with OSHA or DOL is something that the labor board, believe it or not, would be interested in. If the subject matter of that complaint is really a group concern and you go after that employee for that, then you have a problem not only with OSHA or the DOL, but with the NLRB as well. Many of you probably remember the Obama NLRB era and all of the Facebook and social media cases where, you know, the NLRB came out with pretty stringent rules on how employers could police their employees' speech on social media. Those are back. And it is now actually an open question whether the National Labor Relations Act protects employees' right to engage in political movements. And I'll talk about that a little bit later. The board, the National Labor Relations Board, has been around for a long time. It was formed in the 30s. and it's got 5 members. Historically, there have been 3 members from the sitting president's party and 2 from the so-called opposition party. It's always been that way. Right now, there are 4 members. There are 3 Democrats. There's 1 Republican. There's 1 open seat. The way the board does its decision making is not typically by regulation, the way a lot of agencies do it. They do adjudication of cases. So they will process unfair labor practice charges. If merit's found to the charge, the complainant does not get a right to sue letter. The agency actually issues a complaint, and then you have a trial before an NLRB judge. The result of that trial can get appealed up to the NLRB, which is kind of like an appellate court. It's a body of however many, up to 5 individuals, and they issue decisions. And those precedents become our body of labor law. Because of the political nature of the agency, the rules have a tendency to swing back and forth with the political tides, as they definitely have in the past 10 or 15 years. I also wanted to point out that the general counsel within the agency is a really important position. That person also is appointed by the president, confirmed by the Senate, just like the board members. And at the labor board, the general counsel really drives the agency's initiative and drives the change in precedent. That all kind of comes from the general counsel's office. So that's a position to be watching. And we'll talk a little bit about general counsel memos throughout the presentation. And those are actually kind of a roadmap, if you will, if you're paying attention to those, to where the law might be going. Just wanted to talk a little bit about the climate. That I can answer the question that the title of this presentation posed. Yes, unions are cool again. You can see these pictures up on the screen. They're commonplace in news articles and on social media. And sometimes there's a union involved and sometimes there's not. Activism is in, and unions are very much associated with activism. And it's not all that surprising to see these results from a fairly recent Gallup poll, which says that 67% right now of people who are polled have a favorable view of labor unions. And you can see the line graph. You haven't seen numbers that high since the 1960s. You can see around 1980, it got down to about 55. Just after the Great Recession, the Great Crash of 2008, was it? Went down to 48, but it has shot right back up since then. It peaked last year at 71. It's come down a little bit, but there's been a pretty consistent 5-year upward trend. And historically, the numbers are very, very high.
Perhaps an unfair question, but do you think pandemic had anything to do with that, with kind of like employees sort of taking back the reins on demands for wages, benefits, things such as that?
I think that absolutely could have factored into it. I think it's really anybody's guess as to why unions are on the upswing like this. I think it's just, I think it's largely that activism is so in vogue again. Mm-hmm. And when you think picketing, when you think getting out there and doing something, you kind of do associate that with unions. And by the way, unions have done a masterful branding job of associating themselves with Black Lives Matter, Me Too, the Fight for 15. The unions were behind all that stuff. And if you're going to a rally, you're going to see people from SEIU or, another healthcare union or, Unite Here, what have you. They're going to be there and they're going to be talking to people. But I do think the COVID pandemic, I think there's such a perfect storm that has happened, because I think unions were kind of on the upswing anyway. And then you had a pandemic, and then you had inflation, which we hadn't seen in forever. And then you have a really tight job market, and people know that they hold leverage because it's hard to find workers. it's almost inevitable.
Louis, I'm going to interrupt you one
that,
more time because we have a great question from a person named Marco. Do you think the power of social media has impacted the increase on union activity?
I would not say that it doesn't. But yeah, no, I would agree with that. I think that unions have, and they use social media really well when they're trying to organize people to get people to sign up. And so I think they've also utilized social media very well. And I think the rise of social media sort of destabilizing the way people get their information. You're not just looking at, corporate owned news outlets and what have you. I think that's absolutely played into it too. I think there's just a lot of factors. And I think all of those factors are, sort of favoring unions. And that's kind of the climate we're in. Just wanted really quickly, before we move on from this, I just wanted to point out two more statistics, the middle of which I actually think is jarring. 49%, and this all comes from the same Gallup poll it's cited at the bottom of the slide. 49% of people who are not in management, not in HR, meaning 49% of those people who could vote in an election said that they would vote for a union. If you look at those numbers in the late 70s, 33%. 1995, that was almost unchanged at 32%. So that's a huge, huge change. 34% of people also said they thought unions are going to be more powerful in the future. And just a few years ago, in 2018, that was only 19%. So you can see the way that's going. So it should be a surprise to no one that organizing is up. In fiscal year 22, there were over 2,000 NLRB election petitions that were filed. That was almost 65% over fiscal year 21. And you can see I listed a few of the prior years' numbers of petitions. In 2019, which was not that long ago, there weren't even 1,000 of these things. Now there's over 2,000, and it looks like in 2023, we're going to have about the same number as we did in 2022, a little bit over 2,000. Also wanted to point out, there were over 300 work stoppages in 2022, meaning strikes. We have a couple of really high profile strikes going on right now with the auto industry and in Hollywood. And I did not include this in the presentation unless I missed it. No, but I can tell you that 75% of people polled, and this is before the UAW strike started, 75% of the people said, hey, we're with the workers. 72% of the people polled were with the Hollywood writers. And I think it was 67% people polled were with the actors in Hollywood on strike. And those strikes were going on. So the strikers, the workers, the unions have a pretty commanding lead. So the NLRB is all but happy to help out where it can. So let's talk about that a little bit. On August 25th of this year, the Labor Board issued what is by far the most significant decision it's issued in my career, and I've been doing this since 2007. The case is Cemex Construction Materials. It's a revival of a really old case from the 40s called Joy Silk Mills. And actually, it's worse than Joy Silk. So before August 25th, what typically would happen if a union signed up your employees is they might come to you in management and say, hey, we signed up your employees. We'd like you to just look at the cards and recognize us. You would probably say no. And if you would talk to me, you would definitely say no. And the union would have to go file a petition, and that would trigger the election process. What Cemex is saying is that, look, if the union has signed up a majority of your employees, we really think you ought to just look at the cards and recognize the union and start bargaining. But you can still have the election, but you, the employer, are going to have to be the one to come file the petition for the election. And if you don't do that within 2 weeks, you're too late and you're unionized. And by the way, if anything happens during the campaign period that would warrant setting the election aside, we're not going to run a second election because of your mistake. You're going to be unionized based on that. And just to note a couple of things that have been found to warrant a second election in the past, having unlawful handbook rules that weren't even enforced during the campaign period, that's been found to be enough. Threatening or coercive statements during the campaign, like, hey, you know, we know who's behind this, or something that a manager might think is fairly benign, or I don't really think you're going to get anything out of unionizing. It's kind of a waste of your time. If the labor board finds something like that to violate the National Labor Relations Act, instead of holding the second election, you're going to get what's called a bargaining order. The bar to get an election overturned is very, very, very low. And now the stakes couldn't be higher because you're going to wind up with the union if you do anything wrong during this process. So if your employees sign cards, here's what's going to happen. One, the union's going to come to you and say, we represent a majority of your employees, recognize us. You have two options at that point. One, you can look at the cards. If they actually represent a majority, then go ahead and start bargaining. Two, you can decline and file a petition. But if you don't file a petition within 2 weeks, congratulations, you're now unionized. If you do file the petition and you win the election and the union happens to file a charge, and it is going to file a charge, and you committed nothing wrong, did nothing wrong, committed no unfair labor practice at all, then congratulations, you win. If you did anything, a single unfair labor practice, as far as what we can tell, the way CMEX was worded, you're going to get unionized based off that one mistake. That's not all the labor board has done in the election context. They actually changed the election rules the day before CMEX came out on August 24th. Some of you listening to the presentation may remember the so-called ambush election rules or the quickie election rules that were announced in 2014. What those basically did was they deferred a lot of the issues that get litigated when a petition gets filed to after the election, and it speeds up the election timeline by a lot, from 4 to 6 weeks, sometimes longer, to about 3 weeks. In 2019, the labor board issued regulations rolling those rules back, and that all got tied up in court, but some of those things did, some of the new rules did survive. And the outcome of that was that from May of 2020, when those new rules took effect, until the end of this year, you had about 2 weeks added to your campaign time, which is pretty valuable when you're talking about a union election. On December 26th of this year, the new regulations are going to take effect, and we are going to go back to the 2014 so-called quickie election rules. You're going to have about 3 weeks to campaign, and you are going to have most of your issues deferred until after the election, if they're even necessary. So just some best practices in light of CMEX and these rule changes. Number one, it's really important for you to be proactive. NLRA compliance training is now very, very, very important because a wrong move in that regard is going to get you unionized. It's really important that companies have a robust employee relations plan. If your employees are not signing cards, you're not going to get unionized. Conversely, if your employees sign cards, I'm sorry to tell you, but the election is kind of a formality. I don't really think it matters anymore. It's going to be so easy for the union to get it overturned and get a bargaining order that if your employees sign cards, you're probably as good as organized. So you need to figure out a way, if you want to remain union free, to prevent your employees from signing cards. And the way to do that is to figure out what their issues are, keep them happy. Reviewing your handbook, and Donna's going to talk a little bit about what the labor board's done with handbooks. That is really important because, again, there are NLRB cases where elections have been overturned based on handbook rules. So let's get those fixed now. Do not look at the cards. If someone comes up to you and says, hey, I signed up all your employees, say, that's nice. I don't want to see the cards. Do not look at the cards. If you look at the cards, there's a decent chance, I think, with this labor board, that the union's going to be able to argue that if you file a petition, it should be thrown out because you've already looked at the cards and confirmed that the union represents everyone. Don't do it. Finally, seek advice from competent HR professionals or lawyers. All of this is very, very, very arcane, complicated stuff. It is very easy to make a mistake, and it's impossible to walk the mistake back once you've made it. So, you know, it's going to require quick action, but please don't get yourself in a bad situation. One thing I wanted to point out, and this comes from one of those general counsel memos I mentioned, the current general counsel has indicated her intention to tell the board that they should rule unlawful what are called captive audience campaign meetings. Now, when a petition's filed, often the employer will gather everyone together and have a mandatory meeting and say, look, I want to talk to everybody about my views on the union and why we don't think it's a good idea in this workplace. That would be illegal if the board agreed with the general counsel. You could not force employees to come to a meeting to listen to that. Even in voluntary situations where managers are talking to employees, the general counsel is going a step further in saying that your manager would have to go up to the employee and say, listen, I'm going to talk to you about the union, but it's totally up to you if you listen to me. You can walk away, you can put your hands over your ears, and nothing bad's going to happen to you if you do that. Totally voluntary. You don't have to listen to a word I say, and then you can deliver your message. Effectively, campaigning for employers would be close to non-existent if the board adopted this view. Also, just wanted to point out that there are a couple of states that have already put in these captive audience meeting bans. Connecticut, Minnesota, New York just a couple of weeks ago, and Oregon. The Connecticut law is being challenged on constitutional grounds. We don't really know how that's going to come out. Another thing I did want to flag is that the GC filed a brief in a case that's pending at the board, urging a return to a case called Purple Communications, which some of you might remember, which says that employees have the right to use your email systems to engage in union organizing activities. And the GC wants the board to reinstate that case, but to also say they can use company cell phones, WhatsApp, Teams, Zoom, any media that the employer might have, employees can use that to organize. So you can kind of see where the labor board's going with all of this in trying to make organizing much easier for employees. And with that, I'm going to turn it over to Donna to talk to you about handbooks.
Thanks, Louis. You know, before I start this section, we had one pending question, and that is, does an employer, and I'm pretty sure the answer is no, but does an employer need to be notified that the union is collecting signatures in order to become organized?
No, and the number one thing that I hear when I find out that a client has a petition, and I have such a case right now, is I wasn't hearing anything from anyone. I had no idea this was going on. Typically, the union is going to tell employees, make sure no one knows we're doing this, keep it secret, don't talk to anyone about it until they surface, and then you'll start hearing talk about it in the workplace, but there's no requirement that you be told anything. You can have a petition filed and not know that there was a thing going on.
Thanks, Louis. Okay, so let's get into the recent developments at the board regarding handbooks. Louis referred to them a bit. We are heading, and actually we are in the Obama era again regarding handbook rules and things that you might be enforcing in terms of policies in your workplace. The Obama administration took the position that everything had to be looked at on a case-by-case basis to determine whether or not it constituted an unfair labor practice. When the Trump administration came in, they instituted a decision, the board came to a decision in Boeing that gave us three categories of work rules that became very clear to employers, at least a lot more clear to employers, what was going to be found to be unlawful by the board and what was not. And there were three categories, as you see there. One was always lawful, that you could maintain. Category two rules were sort of that in between. And those were rules where the board would look a little more closely and balance and scrutinize the employee rights against the employer interests. And then there was a third category that were totally unlawful, which had been, frankly, for years, things like discussing wages or asking about, why I'm paid something and somebody else isn't. And as you know, those laws now exist at the state and local levels too, those pay transparency and protection laws that the states and localities that you operate in have passed. So those were the three categories. Things like, gee, if I have the word courtesy in my handbook or respect, those things became lawful again. Other things became lawful as well. Regarding videoing in the workplace, there was a lot more generous view, right, towards the employer and what the employer could have in a handbook and also enforce. On August 1st, that changed. So on August 1st, 2023, the board issued the Stericycle decision, and they reverted to that more restrictive framework that is unfavorable to employers. And so it will be looked at on an individualized basis, case by case, determine whether or not that rule that you have in your handbook would be construed by employees to restrict their rights to engage in protected concerted activity under the Act. And as Lewis mentioned a little bit earlier, you don't even necessarily have to enforce that rule for it to be unlawful. The fact that it is there, the board has taken the position that it might restrict that person's ability to come forward and complain in a concerted way about their terms and conditions of employment. So this is a huge impact on employers and how they are writing their handbooks and their work rules. And obviously, as Lewis said, that's something that you really do have to look at now very, very carefully. What they did specifically was went back to a case from 2004, Lutheran Heritage. That is now in the Stericycle standard that employers have to look at when they're thinking about work rules. What might it reasonably lead a person to believe they could not engage in protected activity or can be construed that way? They will look at least they say in Stericycle, and consider whether or not your business interests, are significant enough to maintain that rule. But the idea here is that you need to be narrowly tailoring these rules so that you are not affecting those rights under the National Labor Relations Act. So that is one thing that you need to scrutinize now, because as Lewis said earlier, if you have an unlawful workplace rule or handbook policy, that could get you unionized pretty quickly if that is found to be the case during a unionization campaign, as he just discussed. Lewis, did I miss anything in Stericycle that you'd like to add?
No, and one thing I would point out about Stericycle that I think is really interesting is that it, sort of in the way of window dressing, the board said, oh, we're going to work in one of the aspects of Boeing, and that we're going to consider the employer's business interest. But, the first part of that, legitimate and substantial business interest, fine, that's okay. The narrowly tailored part of that, I think they didn't really give much guidance on that. I don't see how any rule is going to survive. If it is found initially to be unlawful, I don't see how you're going to get around that. I mean, this is very
I mean, if you go back to Obama, right, we had those decisions that you were referring to, like a like on Facebook to somebody's complaint about wages or other terms and conditions of employment was construed as protected concerted activity. The word respect, the word courtesy. I mean, they were very
here's
interesting decisions that employers had to deal with and are going to face now as well.
Here's a good one. Walking off the job, being at work on time, you can't tell people that now, according to the labor board. because they think that's telling people they can't strike. This is
Right.
the agency you're dealing with. This is the agency you're trying to prove that you tailored your rule as narrowly as possible. So just take that into consideration.
Thank you, Louis. All right. All right. Let me go to our next slide. So some work rules you should be thinking about that are probably at risk right now or are at risk. Those disrespectful, or you got to be respectful to customers, clients, other employees, and towards management. That's probably an issue. You should be thinking about changing that language. I like the word professionalism, perhaps, in the workplace, but you have to look at that language. Use of cell phones, cameras in the workplace. Failure to report and no show, no call, as Louis was just saying. Insubordination or failure to follow directives. The insubordination word should have left your handbook years and years and years ago. It's not a great word. And you really have to think about the behavior that you're trying to address. And insubordination is a very broad term and probably won't do it for you. It could get you in trouble here. Defamatory statements about the or disparaging about the employer's, coworkers, management. You can't say those things at work, for example. How you your restrictions on use of intellectual property, and conduct that, quote, is not in the best interest of you as the employer. You know, what does that really mean? Well, unionization may not be in your best interest, right? So if you had a line like that in your handbook, that could get you in trouble with the board. So those are some of the things that you should really start focusing on when you're thinking about reviewing that handbook. And if you haven't done it in a few years, you really should take that project on. And we all hate them. We all hate the handbooks. We all hate the handbook review. We know that. But you really have to think about it now. So Stericycle in conjunction with CEMEX. I'm going to let Louis take that one. Louis, you want to speak to that?
Before that, there was a case from about 2012, but I was totally wrong about that, if I said that. But no, there was a case, it was from 2011 at a hotel. The hotel had 3 unlawful work rules that were maintained. They were not enforced. There was no evidence anyone looked at them because who the heck sits around reading the handbook? But during the campaign period at a hotel, and Unite Here, which is a very litigious union, lost the election and said, hey, let's find a way to get this thing overturned and get a second bite at the apple. That did it. And in fact, the dissent in CEMEX, and I had come to this conclusion before I even read it in the dissent said, under Jury's Boston Hotel, an illegal work rule in a handbook is going to get a bargaining order imposed on an employer. And by the way, under our recent decision in Stericycle, no employer has a handbook without illegal work rules in it. That's what we're doing here, in case anyone's wondering. So that's really, I just wanted to drive home the point that, you know, this isn't just, oh, we have to look at the handbook because if something's in there, we're going to have to post a notice. This has real potential consequences.
Thank you, Louis. All right. So we've said it, but why not say it again, right? Get the handbooks out, look at them, think about ways to narrow the rule. Why do you have the rule? What is the business reason for the rule? Work with your attorneys on this to make sure you're getting it as narrowly tailored as possible and in compliance with where we are right now at the board level. Those are really important things to do. It is a low bar, right? When you're thinking about what might restrict a person from engaging in protected concerted activity. And when you're thinking about those types of rules, you can also think about it more broadly in terms of discrimination and other laws that might come into play at the state or local level. So some of these things really start to tie together very neatly, depending on the jurisdiction that you're in and the rules and the statutes and regulations in a particular jurisdiction, not just at the federal level. So really important at this point in time. We also think you should be on the lookout for a reversal of 2 cases, Apogee Retail and Banner Health. And in those cases, Louis, you're going to have to remind me. I've had a loss of memory for a minute on the slide. I apologize.
I'll tell you, Banner Health is everyone's favorite decision. It's the one that says you can't tell people to keep the contents of a, let's say, a
That's
sexual
it.
harassment
Thank you. And
investigation
I do
confidential.
not know why that slipped my mind at that moment because I do a lot of investigations in my practice. But the system that we're in now with the board says that if you are, as HR, as an employer, are conducting an investigation, you may, during the course of the investigation only, right, restrict or let people know that you have to maintain confidentiality. You can do that during the investigation, and you can do that now. That was the Apogee retail case in 2019, again during the Trump administration. Banner Health was just the opposite. It found that an HR person engaged in unlawful activity when they restricted employees' rights to talk about the investigation at work and during the course of the investigation. So we're looking for a flip back to that standard as well. And it is very, very important that when you're thinking about what the board is doing as well, how that interacts, as I said already, with other like Title VII and other employment statutes. There's often a friction between our harassment policies or our discrimination policies and some of the conduct that the board might say is lawful under the act. So that is a sort of a natural friction that employers are constantly dealing with as the board starts to kick up with some of these decisions. All right. Okay, now I think you all, if you attended an earlier chat this year, we covered McLaren-Macomb, but this was a really interesting decision by the board in February. And what the board, in short, is telling employers is that if you offer, they don't have to even execute it, but if you offer a non-supervisory, non-managerial employee a severance agreement, which has bad language in it, basically, related to confidentiality of the agreement and non-disclosure, again, saying bad things about the business, about the owners, about whomever, if those kinds of provisions are overly broad, that could result in an unfair labor practice. And that's really what the board held in McLaren-Macomb, that these types of provisions that are overly broad and not narrowly drawn are going to be found to be unlawful by the board. So you can see the language, right? The language that was at issue in McLaren. So pretty broad language. So the board's reasoning behind this was that, it restricts those rights because it restricts folks from making public statements about the workplace, right? If you say you can't go on social media, you can't talk to your neighbors about us, whatever it may be, that is restricting protected activity. It doesn't allow employees to assist coworkers or former coworkers with any workplace issues they may have. It restricts employees, or at least can be construed to restrict employees from being involved in investigations and litigations related to the act or the board and so forth. So it's kind of at the state level, you've seen this as well. New York, California, Washington State, Maryland has a version of it. Other jurisdictions have also said you can't include these NDAs, or you have to narrowly tailor them, or you have to put some type of safe harbor language in those agreements so that employees understand the rights that they still have, notwithstanding the language that you put in that agreement. All right, so another general counsel memo. This was a really interesting memo that came out in March after the McLaren decision. And it was a little scary, I think, for employers who have to deal with all of this change at the board level. One of the questions in that memo was, are agreements offered to supervisors, those who aren't protected by the act, are they exempt from the McLaren decision? And the board said not maybe not. But the board's position was it would be unlawful for the employer to offer an overbroad agreement to a supervisor because they might be prevented from participating in a board proceeding. That was a surprise because supervisors aren't covered by the act. but it's the idea that you're restricting those supervisors maybe from participating on behalf of employees or supporting employees in their efforts. Is the decision prospective or retroactive? The board said this decision is retroactive, but they didn't really say much to that. So the board's position is any agreement that you entered into prior to the effective date of McLaren would be unlawful if it had overly broad provisions in it. But they haven't given any more guidance on that. And to my knowledge, Louis, they haven't attacked any employers yet on prior agreements before the McLaren decision was issued. I mean, just thinking about that practically, it would be really, really hard to go back and amend agreements that you were had previously issued to employees and paid severance.
Probably would need a time machine for that. I don't know.
Yeah. What if the employee is the party asking for, I want this to be confidential and I don't want you to disparage me either. Let's, have some mutual provisions in there. The board says that would still be unlawful, that even if the employee is agreeing to it or asking for it. All right. All right. So what else here? Can you have any of these types of provisions, confidentiality or non-disparagement? Maybe. So if it's really narrow and it protects your business information or proprietary information, but for a limited period of time, not for the rest of the person's, natural life, and non-disparagement, if it is, again, narrowly tailored and focused really on defamatory statements, right? Those would be unlawful statements, not truthful statements, statements that are in reckless disregard of the truth, willful, right? False statements. So the language that you are using in your separation agreements, I still see, which, some states have banned, non-disparagement clauses in employment agreements. Offer letters, depending on the jurisdiction that you're in, those things are not lawful at the state level either. So you really do have to think about what you're doing on both ends when you're hiring the person as well as when you're exiting them. And then they have said, the board in this memo, that non-compete, and they have gone after both non-compete and non-solicitation since this memo came out. Non-compete, non-solicitation, non-poaching, which is a whole trend now too, at the state level and the federal level, new coach agreements, and banning those. Broad releases that go beyond the employer and include a lot of entities and releasees, et cetera, might violate the NLRA. They did say you can add a savings clause. Maybe that would cure the overbroad language, but you have to tell the person a whole lot of things.
Well, all you have to do is tell them they have the right to unionize, the right to bash the employer, the right to wear union buttons, the right to do this and that and the other thing.
That's right, Louis. All those lovely things on the screen, you would have to set out in your agreement for the safe harbor language to be valid. You all probably do remember there was this trend back in the day where everybody was putting these short sort of safe harbor sentences in their handbooks under policies or generally in their handbook that said, oh, nothing in this document or this policy or this handbook is intended to or does, restrict your right to engage in protected concerted activity under the National Labor Relations Act. Well, clearly the board is not going to accept that language in these types of agreements, and probably not in a handbook either, as we talked about a little bit earlier. So we just mentioned, but saying it again, the general counsel is looking at non-competes. They just issued a decision this week on non-solicitation language that they took issue with as unlawful. So a lot happening in this area of the law. So I am going to ask you to be on the lookout for more on non-competes, more on non-solicitations. All of that, you need to really stay aware right now because the board is really active. I think, Louis, you probably tested this better than I, but I think most of these decisions came out over the last 6 to 8 weeks, if I'm correct on the timing. So there's been a huge shift.
And really in the last 3 or so weeks, I've never seen the labor board as active as I have in the last couple of weeks.
And, you know, the last reminder here, Lewis talked about the CMEX case. Just maintaining a rule, right, even if it's not enforced, could result in a bargaining order and your business being unionized. So there really is a lot to think about here. So Lewis is going to take back the reins and he's going to talk about employee conduct and PCA expansion.
All good news. A couple of decisions came out at the end of August that expand the definitions of concerted and of protected. The first case was Miller Plastics, and it overturns a case called Allstate Maintenance and reinstates a case called Worldmark by Wyndham. Now, in the Worldmark case, there's an employee who complained, was in a hotel to his manager about a dress code policy and said, is this just us, this group of my department that's covered by the dress code policy, or is it everyone else? One of his coworkers was walking by and said, yeah, I agree with that. I have that question too. And the employee was fired, and the board said that was enough to be concerted, just because another employee was walking by and the employee said, we. Allstate said, no, that's not enough. And it overturned Worldmark. In Allstate, there was a skycap at an airport who had complained to his supervisor about a soccer team and their bad tips. The team returned, and the skycap and his coworkers kind of walked off and said, you know, we're not doing this. The whole case revolved around that complaint that the skycap made to a supervisor about tips. And the board there said, no, that's not enough. That's a straight comment. But under Miller Plastics, the Worldmark case is now protected again. So if you have an employee kind of complaining in the hallway and saying we and us, and there happens to be a coworker walking by, that raises a serious question to me as to whether that there's actually concerted activity going on, even though to any normal, rational person, it looks like there's one employee griping to his manager. Protected. There's a case involved called American Federation for Children, same day, August 31st. There was an employee who advocated to management that, hey, we should rehire a former employee, later got discharged for it. Everyone on the panel, including the one Republican, they all agreed that the NLRA covers and has covered for many years former employees. So what's the big deal? But the board said, you know what, while we're here, we're going to overturn a case called Amnesty International, which was from 2019. In that case, some employees had signed a petition on behalf of unpaid interns and later got fired for it. And the board said, well, unpaid interns are not employees, and that's not working conditions. So yeah, you all got together to do it, but it wasn't a protected subject. Well, now the board has decided, well, if it's something that's what they said outside the immediate employment context, it's going to be protected if it's undertaken on behalf of non-employees in such a way that employees could benefit. And I guess if the interns came back, the interns would help out the employees and the employees would benefit in that sense. So it seems to me to be a very, very low bar. I just wanted to highlight a couple of judge decisions, but I'll touch on them really briefly. One case is Fred Meyer Stores. A judge decided that employees wearing BLM, Black Lives Matter pins was protected in the workplace, even though that's a political movement, because the employer had publicly said, hey, we're all for Black Lives Matter. We're behind it. And the employee said, we don't buy it. And they wore the pins. They were told to take the pins off. They didn't. They got fired. And the judge put them all back to work. There's another case called Korean Resource Center, which was a community resource center in the Koreatown neighborhood of Los Angeles. They were going to paint a mural on their building expressing the message of Asian and Black solidarity, and all about togetherness. And there was an employee who said, well, I don't really think this is correct. This isn't right. It's going to offend the community. And actually, I think some of my coworkers are going to be offended by this. The employee got fired. And the judge said, you know what, that doesn't really have to do with the workplace. That has to do with what the employer is doing, outside literally of the workplace by painting a mural on the wall There's no connection. So I don't see how those two decisions can be reconciled, but they do implicate sort of political activity and how they do seem to be bleeding into the workplace. And again, these are not board decisions. These are from judges. Both of those cases are pending in Washington. So, just be on the lookout for what happens with that. I think we're kind of running short on time. I just wanted to touch really, really quickly on a case that came out in June on independent contractors called the Atlanta Opera. Going forward, if you engage independent contractors, the really important thing, and you can see the factors that the Labor Board uses in its test for independent contractor status. And by the way, the DOL has its own test. States have their own test. It's rather confusing area. The one factor that really is going to matter going forward is number 10. Is that contractor really in business for themselves? Meaning, can they actually work for other companies, or do they just work for you? Do they have any kind of an ownership interest in their work, proprietary interest of some kind? And do they control important business decisions like scheduling, when they're going to do the work, hiring their own employees, purchasing their own equipment, capital contributions for their business? If those kind of things are not there, that independent contractor is an employee, and that independent contractor can unionize under you. The joint employee
Louis, I know
rule,
we're running out of time. I'm just going to say one quick thing to put in everybody's head. Jurisdictions are covering independent contractors under their anti-discrimination laws. New York and DC are two recent examples of that. So, not only the misclassification problem under wage and hour laws and the problems here, but even if you misclassify and you are calling them an independent contractor in certain jurisdictions now, they are covered by the anti-discrimination laws. So you have to carefully make sure you're exiting your ICs the way you might think about exiting an employee as well in certain jurisdictions.
If you don't keep a bottle in your desk, you should probably go to the nearest bar right after this. Joint employer rule. In 2015, you might remember the Browning-Ferris case from the Labor Board. That case basically said if you use a staffing agency to get employees and you reserve the right, don't exercise, but reserve the right to control directly or indirectly essential working conditions like pay, hours of work, benefits, hiring, firing, stuff like that, you're a joint employer. And why is that important? Well, if you're the joint employer, and you can see here on the slide, the employees in that case, Lead Point, they provided employees to BFI and their employees unionized. And the union came to the table and said, hey, Lead Point, nice to see you. Go call Browning-Ferris because they're also the employer. So that has serious repercussions. In 2020, the board issued regulations that really cracked down on the joint employer rule and said, look, if you're doing a cost plus contract, that's not enough to make you a joint employer. You have to actually dictate what the contractor's paying their employees. If you're not doing that, you're not a joint employer. You have to pick what benefits they're getting. It's not enough that you're allowing the contractor's employees to participate in some of your benefits. Hours of work, just because you're telling your contractor what hours you need their people, which of course you're going to do that, that's not enough to control their hours of work. And for hiring and firing, it's not enough under these rules that you implement standards, or if someone comes to the workplace acting like an insane person and you say, look, they're not welcome back here, that doesn't mean you fired them. That's not enough. That's not direct enough. But effective, who knows when, but the rules were supposed to be made effective last month. They haven't been, so they have to be coming any day now. There are going to be regulations rolling back the current regulations and going back to the Browning-Ferris standard, which is indirect control is enough and unexercised control is enough. And so it's really important. And I did a lot of this in 2015, 16, 17, and 18. You're going to want to look at your contracts with staffing agencies. You're going to want to see if there's potential exposure there. You're going to want to see if you can redo those contracts, because you could wind up finding yourself the employer of a bunch of employees that you didn't know you employed. As far as the independent contractor situation, just take a look at how you're using them. Are they really independent contractors? Are they actually in business for themselves? If not, you need to figure out what to do with them. You might want to just change their status because they might be employees anyway. And you know what? Make them employees and then implement some kind of an employee relations plan. Make sure they're happy so they don't unionize. With respect to your staffing agencies, because of the nature of your business, I see a lot of these staffing relationships in hospitals, in hotels. Sometimes it's not possible to not exercise control over those workers. You're going to be a joint employer, so act accordingly. Just know that you're going to be on the hook for unfair labor practices, and know that if those employees unionize, you can be on the hook too. You could be sitting at the bargaining table. And I think that brings us to the end. A couple of takeaways actually before we go. The board has been really, really aggressive in broadening the coverage of the law. That is not an accident. I think everything you see the board doing right now has got to be viewed through the lens of CEMEX. The general counsel did not make any bones about the fact that she wants to see a lot more employees organized and members of unions. And that really is what all of these decisions have been about. So our recommendations are: get that handbook reviewed. It's more important now than ever. Look at your robust employee relations plan. I do those all the time as part of my practice. If you want to talk about that, give me an email. Look at your independent contractor relationships. Look at what you're doing with staffing agencies. You might need some changes there. And any potential discipline where you have an employee who's complaining or trying to bring about change as it relates to working conditions, before you discipline them, before you fire them, kind of step back and look at whether you really should do that, or whether you should do it, take another way about it so that you don't have a problem with the NLRB.
And Louis, just as a kind of capping that all off, a lot of the things that we talked about today really are happening at the state and local levels as well. So if you haven't thought about your documents, your handbooks, your agreements, all of the things that we've referenced here, it really is the time now to do that with your talented HR staff and your employment and labor counsel to try to narrow your liability, or at least minimize or mitigate it. I really want to thank Louis for his presentation today and all the work he put into it. And we're so happy to have him on the team. Hopefully you enjoyed today's session. Please do give us some feedback because we appreciate hearing it. Thank you for attending today.
Thanks, everyone.